Yeah, we can start.
Everyone, hope everyone is doing good and staying safe. Thank you all for joining us today in this legit class. I'm Chahat Verma, moderator for the session, and I'm deeply honored to have Ms. Anuradha Agnihotri and Mr. Faisal Sherwani as our esteemed speakers today. Our first speaker is Mr. Faisal Sherwani. He's an advocate on record, Supreme Court of India, and is currently partner in the dispute resolution practice at L&L Partners, New Delhi. With an experience of over a decade in the field of dispute resolution and dispute advisory services, he has a deep understanding of procedural and substantive issues of law. He regularly practices before the Honorable Supreme Court of India, as well as before the Honorable High Courts of Delhi, Bombay, Karnataka, Telangana, Allahabad and Madras, and also before NCLT and NCLAT. Welcome, Faisal, sir. Thank you for joining us today.
Thank you for the introduction, Chahat, very much. Allow me to say that I'm very delighted and honored to be speaking to you all today. I'd like to thank LegitClass and Karan for making this interaction possible. Would you like me to start right away then?
Sure, sir. You can start, and I'll pass it on to Anuradha, ma'am.
Sounds good. Okay, so today's topic of discussion, the class, so to speak, arbitration versus operation and mismanagement under Section 241 and 242 of the Companies Act 2013 is really indicative of a larger issue. The larger issue is how to resolve shareholder disputes, so to speak. What is the apt mechanism? And necessarily when you make that inquiry, you will have to play around and see that there is a clear dichotomy between the laws relating to an arbitration of a shareholder dispute and an action for operation and mismanagement under the Companies Act in Section 241 and 242, the law as it stands. So once you look at it, I think I'll start a little bit with the expression of operation and oppressive itself. I think you'll find an earlier exposition of the expression in an Old English case, 1940, under the 1948 Act there, Section 210. It's called Scottish Cooperative Wholesale Society versus Meyer. And there really the expression was interpreted to mean something which was burdensome, harsh, and wrongful. Of course, wrongful not in the sense of an utter illegality, but a departure from something which was considered to be fair dealing, something which was unfairly prejudicial. Later, the Jenkins Committee report had clarified, and that is how the expression came to be understood all this while. So when we look at the issue, we necessarily have to consider what is the effect of an arbitration clause. Does it oust in effect the jurisdiction of the NCLT under Section 241 and 242? And what is the law? How has it evolved? That is what I had thought that I will talk to you all about a little bit. So I'll start with the 1940 Act, the Arbitration Act of 1940. And the position there, I think, was rather consistent to the extent that the point of view of the courts was that a proceeding by its very nature under Section 397 and 398 was incapable of being referred to an arbitration. Possibly with good reason, because there was no mandatory provision such as Section 8 as you have under the Arbitration and Conciliation Act of 1996. What you had was Section 34, and there was a provision in that for stay of proceedings in the event that an issue was covered by way of an arbitration agreement. And it was, I might add, a completely discretionary relief as far as the court was concerned. And principally, the court, like I said, had followed the broad perception that the relief under 397 and 398 of the Companies Act, this is the erstwhile Act, of course, of 1956, was one which had its origins in statute and not so much in common law, although if somebody might disagree. because you could dig up case law which showed that you could maintain an action, a civil action or a suit for operation and mismanagement prior to there being any statute whatsoever. Of course, the law of companies, so to speak, has preceded a statute. In that sense, you did have companies and corporates before you had a law regulating them. But nonetheless, that is where the court found itself. And inherently, as a necessary corollary, you could say that no jurisdiction or relating to corporate affairs of a company could be vested in an arbitrator by virtue of the Companies Act, to the extent that you could dig up and find precedent which said that to have an arbitration clause of that nature would be a contravention of Section 9 of the Companies Act of 1956, in the sense that it would be repugnant to the provisions of the Act. Being a matter clearly covered by statute, you could not have it resolved by way of a private arbitration. So that is what the law was. You could, of course, find a stray decision here or there where the parties had been referred to arbitration, but I've always understood them more to be because these cases were essentially earlier dealt with before the high courts, and the parties somewhere had resolved that they were willing to go to arbitration, broadly speaking. Switching over to the 1996 Act, and this is where the whole position starts to get a little muddled. And you will see as I take you through the law, I'll endeavor to not overshoot my time. As I take you through the law, you'll see it's been a series of flip. And I think the first decision, many commentators start with the decision in Naveen Kedia versus Chennai Power Corporation. It's a 1999 decision after the act had come into force, the 1996 Act. And it was essentially a Section 45 action, which was filed to refer the dispute to arbitration. And the petitioner there had in some sense admitted that the operation and mismanagement arose out of the provisions of the shareholders agreement. But arguments were certainly made twofold to my mind, the way I read Naveen Kedia, that the first line of argument really was that, and this was made by the parties who were resisting the arbitration, obviously, that 397 and 398, a proceeding of that nature could not be decided by way of a private arbitral resolution process at all. That argument is certainly made there, though some people seem to suggest that it wasn't. To my mind, it was. And there was a second set of argument, which was that I cannot get the sort of relief that I can get before the CLB, and at that point it was the CLB, and then which I can get before the CLB. An arbitrator is really incapable of granting me that sort of relief. The contentions come to be rejected by the CLB, and it holds that the issues, as long as they were covered by an arbitration agreement or an arbitration clause, then the matter would necessarily have to be referred to arbitration. And now obviously you remember that Section 8 is there in the new act, it has come into force, and therefore there is a different outlook and different approach to the matter. Almost to the extent that what is suggested is that even if the relief, as you say, it cannot be granted, and this contention is addressed in some sense, the CLB says, even if you cannot get the relief which you pray for before the NCLT, that is not an inquiry which we will make at this stage, and that is entirely extraneous to the issue. As long as the issue is covered by way of an arbitration clause, that by and of itself is sufficient to refer the parties to arbitration. And thereafter you have the Haryana Telecom case. I think everybody who has paid attention to the subject is conscious of that judgment. And that has been understood to generally mean that the Supreme Court had laid down that matters in a winding up petition could never really be referred to an arbitrator. And the arbitrator would have no power, of course, to decide an issue such as winding up. Similarly, by the same logic, matters which would be covered under 397 and 398 of the petition of a petition could not be referred to an arbitrator, properly speaking. Thereafter, you have the case of Bhadresh Kantilal Shah. That is again a section 45 petition. The issue of arbitrability was again urged, but ultimately the court finds that there is no commonality of the parties, and matters were made particularly easy on account of the fact that the company itself was not a party to the arbitration clause, and therefore the CLB declines to refer the parties to arbitration. So it is a precedent of sorts, but you understand that the factual scenario was one where a reasonable mind possibly would have declined arbitration in any case. Then comes the AirTouch International case, where the CLB, again, in a section 45 petition, section 45 action, held that a dispute within the meaning of 397 and 398 of the Companies Act would indeed be referred to arbitration. Clearly says that can be referred to arbitration. And AirTouch case, and this line of cases really rely on a Supreme Court order of that time, which is unreported, to actually come to this conclusion. But fairly speaking, Naveen Kedia is also referred to, so that is not by and of itself the only thing which is relied upon. Haryana Telecom is also relied upon. So that is that line of cases. But all that while, and a line sort of, a pattern sort of starts to emerge. The CLB and even today the NCLT, they did not refer parties to arbitration in, let's say, a proceeding which is launched under section 397 and 398, where obviously, let's say, the company is not a party. So that's not a problematic sort of a position at all. Equally, if necessary and proper parties to the proceedings are not parties to the arbitration agreement, there is no commonality in that sense. The court, the CLB, had declined to refer parties to arbitration. Similarly, today, the NCLT. If the flavor of the accusations in the petition points towards, let's say, a statutory violation, then it is something which has been seen as being incapable of resolution by way of arbitration. Then waiver has been looked, and you'll find a flavor of that in Vikram Bakshi versus McDonald's, where because proceedings had been pending before the CLB for a long period of time, subsequently when an application was moved to refer the parties to arbitration, that was declined because it was thought that that possibility had been waived, and that really falls under the exclusion sort of exception, which is the arbitration agreement is rendered inoperative. That there was indeed an arbitration agreement or an arbitration clause, which could have very well been used to resolve the dispute between the parties, but because of your own failure and because you have waived the right to have it resolved by arbitration, it is rendered inoperative. So that's a separate class, so to speak. So largely the inquiry had been that, whether the parties in the arbitration clause and those in the petition were the same, and this was a massive factor, and whether the subject matter of the arbitration agreement and the subject matter of the petition were the same or substantially the same. I mean, that is generally speaking the inquiry which the courts have followed throughout, and that is, you'll find various judicial authority for that proposition, and I won't hammer the point further to that extent. Then I think we can switch over to the Hind Samachar case, and this is the case of the Punjab and Haryana High Court, the division bench, and it sort of takes us back to the 1940 regime, and it basically relies on a lot of earlier case law and comes to the conclusion that an action under section 241 and 242 of the Companies Act is incapable of being resolved by arbitration, and that these are powers really which the arbitral tribunal would never have. That's where the Punjab and division bench of the Punjab and Haryana High Court lands up. But despite that judgment, there is a series of cases around 2010, and you will find that despite Hind Samachar and despite Haryana Telecom, they go on to hold that if the subject matter of a dispute is, let's say, in an operation and mismanagement action is covered by an arbitration agreement, then the mandate of the Arbitration Act required that the very dispute should be referred to arbitration. You will find some amount of case law on that also. Then I think we can switch over to, I'll notice the Everest case in the Supreme Court, which is followed by the Delhi High Court, I think in the case of Vijay Shekri. And there, they sort of agree with that line of cases of the CLB, which date back to 2010. And the conclusion sort of is that you can very well refer these matters to arbitration. Matters concerning corporate affairs and affairs of a company by and of itself are not incapable of resolution. Being commercial in nature, essentially inter se the parties, there can be no general rule that they are incapable of arbitration. And then I think, keeping my eye on the clock, I'll switch over to the case which I think everybody relies on today, because it really gives us something to latch on to. That is the case of Rakesh Malhotra, decided by the Bombay High Court. And what the Bombay High Court essentially held there was that a Section 397 and a Section 398 action is essentially an action in rem, okay? And therefore, properly instituted proceedings of that nature would not be referable to arbitration. That's really, to my mind, the ratio. But what the Bombay High Court does do, the single judge does do, is that it carves out a useful exception, and it says that unless you can, I mean, in certain circumstances, refer such a dispute to arbitration, but what you need to test is if the petition is mala fide or vexatious, or whether the petition has been, an expression used is dressed up to look like, you know, an operation and mismanagement sort of an issue where you're trying to avoid arbitration. So it's the cleverness of the draftsman. You can make, you know, any sort of dispute look a certain way with the way you draft. But once you loosen all of the bells and whistles, I think, when you look at it bare bones, you see that it's essentially something which is inter se a commercial dispute between the parties, which very many of these matters really are in essence and in nature, because these are closely held companies, and you will find that most disputes are contractual and commercial in nature, and really third party rights, generally speaking, would not ever be affected. So that exception is carved out, but how that exception is to be used, how it is to be pressed into service is still left a little doubtful. What is the nature of the inquiry? How is it to be? Is it to be applied? I think is it to be looked at only in a prima facie fashion, or do you really go into the meat of the matter and the substance of the dispute to see whether, in essence, it is vexatious or whether it is dressed up to look like an operation and mismanagement action? That is somewhat unclear, but it's a helpful exception. It gives us something to latch on to today. So if I was to sum up that entire sort of discourse and the case law that I've run through very quickly, I think you could safely conclude, and some people might disagree, who really believe that, you know, simply having an arbitration clause would oust the jurisdiction of the NCLT. But I think I would conclude saying that today the law as it stands is somewhat in a state of uncertainty, and courts have taken divergent views, but it would be safe to assume that per se, merely having an arbitration clause by and of itself would not exclude the jurisdiction of the National Company Law Tribunal. But you could find case law that suggests otherwise also. The Supreme Court has not authoritatively taken a position on this, but if you look at the judgment in Vijay Shekri, like I said, in the Everest case, you could find some indication to suggest that these issues are arbitrable. But do remember that those cases did not essentially concern a 397 action or a 241 action. It was essentially a section 11 case, I believe Everest was. That is where the Supreme Court, section 11 of the Arbitration and Conciliation Act, but you could read that judgment a certain way, that order a certain way, to indicate that these disputes are referable to arbitration. So by and large, the way I would put it, like I said, at the cost of repetition, that many of these disputes will find to be contractual disputes, because these are more often than not closely held companies. And these are and should be capable of being resolved by way of arbitration. Of course, the exception in Rakesh Malhotra, you can look at it and see qualitatively that, of course, it's easier said than done, but qualitatively, whether it's dressed up to look like an operation and mismanagement action. You can also look, and this has been a massive factor with courts, I think, in the NCLT, as to what are the reliefs which you are seeking. Is the relief which you are seeking in your action for operation and mismanagement somewhat similar to an issue which is covered by the arbitration clause and capable of being granted by the arbitrator? Then it's a little bit of a no-brainer. You should be referred to arbitration. There's a little bit of a dispute and a debate there also, because when you look at a dispute, your relief should be irrelevant, because technically we only look at the arbitration clause. And if that there is a valid arbitration clause covering the subject matter, whether the arbitrator is capable of giving you all of those reliefs is entirely an extraneous issue. That's one school of thought. But reliefs, you can look at commonality of parties. Generally speaking, I'll put it that way. And of course, you can always make the larger point in law that the Supreme Court has considered in at least a few cases like Booz, Allen, and Ayaswamy as to what issues are arbitrable. And I understand that lease issues and tenancy and landlord disputes today are still pending now consideration afresh before the Supreme Court and larger bench. But none of these judgments have ever held that issues such as those covered by 241 and 242 are entirely incapable of being arbitrated. So I think that is also something which points in the direction of these issues being capable of resolution by way of an arbitration, as long as third party rights are not disturbed. Easier said than done, but that is, I think, where the law stands as of right now. I think I've overshot my time a little bit, but those are my opening thoughts, and I think it would be helpful now. I think Anuradha is going to give, among other things, a little bit of tips about people as to how to draft your arbitration clauses so that you can avoid this sort of trouble that if you want to go to arbitration. So I think I'll ask the moderator to switch it over then if there is nothing else right now.
Thank you so much, Faisal sir. Our next speaker is Ms. Anuradha Agnihotri. Ms. Anuradha is a partner at Trilegal and part of the dispute resolution team. Ms. Anuradha has extensive experience in foreign seated and domestic arbitration, as well as litigation in the Bombay and Karnataka High Courts, Supreme Court, and the High Courts and District Courts across India. She's a member of the Bar Council of Maharashtra and Goa. Welcome, Anuradha ma'am. Thank you for joining us today. I'll hand over the next session to you.
Thanks so much. And thanks to Faisal for the excellent summary of the law. I think it was a real task to set this kind of a topic into a short period. Hello, can you hear me?
Yes, ma'am, you're audible.
Yeah, sorry. It was a real task to set such a short topic, such a complex topic into a short summary, but I think Faisal, you've done a great job. And the reason I say this is because just as an anecdote, when I started practice and my first oppression mismanagement case, that may have been about 12, 14 years back, and my senior, who had at that time about 35 years of experience, I remember him telling the clients that, you know, this question is a very vexed question. And we are here now 14 years later, and I think as Faisal's analysis of the cases showed, it continues to be a vexed question for all of us. because as Faisal said, there's no clarity on, well, not enough clarity on whether oppression mismanagement matters can actually be referred to arbitration. So I think the law and the case law, as Faisal mentioned, is pretty, I mean, all of you have heard. I'll talk about how things work a little bit in practice and how we see them playing out, because there are some things that we see very, very commonly through all of these oppression mismanagement disputes. And I thought I'd just talk a little bit about that. And I think the first thing I'll talk about is, what do parties actually want? When there is a dispute between two shareholders, what is the end result that we are looking at? And while of course there are a lot of, in shareholder disputes, I keep telling clients that it's not an easy thing to fight out, because it's like, it gets very personal. There's a lot of activity at the board. There's a lot of activity at the shareholder levels. There are board meetings called which are challenged by the other side. There are shareholders meeting calls which are challenged by the other side, because, one party has proposed action which the other party doesn't like. So shareholder disputes tend to be real, fight for your life kind of situation. And it is something it gets personal, because there are a lot of people interacting, at the board level, etc. And at the end of the day, I think the question that everyone needs to look at, and I consistently advise clients to do so, is what is the end goal in all of this? Yes, you're fighting. Yes, you're not getting along in the company. But what is it that you wish to get out of this? And I think the common thread that comes through, as is very obvious, is that to maximize your shareholding in the company, the value of your shareholding, not to allow another party to unfairly devalue your shareholding, whether it be by way of diluting your control, your veto rights in the company, or just issuing more shares and diluting your shareholding down to, say, if today it's 20%, diluting you down to 10%, which will decrease the value of your shareholding. So these are the kind of situations in which we see oppression mismanagement cases come out. And I think the key thing to understand, which at least helps me understand this, is that why do we need this oppression mismanagement remedy? And we need it because though directors have fiduciary duties towards their company, shareholders don't have such a fiduciary duty. So actually, if it's in my business interest to do not do something that's very beneficial for the company, I'm free to do it. The company may suffer, its finances may suffer, but as a shareholder, I don't really have any legal fiduciary duty towards the company. So when there is an other person in the company, a co-shareholder, it becomes important to give the co-shareholder this right, because so statute recognizes that even the shareholder has certain rights, and one shareholder cannot unfairly act so as to act against the interests of the company, which may impact my shareholding. This could be done in many ways. Say if there are business relationships, that the company has with the shareholder, and the shareholder is not doing something that may be in the best interest of the company, or many kinds of situations where you may want to bring in new shareholders and the other shareholder doesn't like it. There could be several actions which are considered oppressive to a shareholder, because the statute recognizes that as a shareholder we have several rights in the company, including right to appoint directors, right to attend meetings, right to see the accounts of the company at the end of every year. And if any of my shareholders' rights I'm not being able to exercise properly because of another person's action, and the other person may not have fiduciary duties towards the company, I can actually complain and say that, hey, this is oppressive to me, and now the NCLT, earlier the CLB, please intervene and protect my rights. So this is the kind of situation in which we see oppression mismanagement disputes come out. And typically the remedy, which especially nowadays we are seeing, is two things. One is, of course, we want to maximize value of the company. We don't want it to go down. And the second thing is, it typically, especially if there are just two big groups of shareholders, it typically ends in one party buying out the other party to say, look, we don't get along anymore. Why don't you buy my shares at a particular value and you run the company? It becomes more challenging when both parties want to run the company. So both parties want to buy. This happens when you have joint ventures. If you have joint venture agreements and you have two shareholders who are very much interested in the business of the company, you will see that both of them want to retain their control and want to continue to be in the company. As against that, if you see private equity shareholders or venture capital shareholders, they are not interested really in running the company. They want to leave it to the promoter, but they want to support the business. So they are not interested in actually taking lead and running the company. In that case, it's not so much of a fight to buy out one party. It's not so much of a fight over control, but it is likely that, the investors want an exit. So these are the kind of situations that we see. And the ultimate goal, of course, 99% of these cases is to get a commercially negotiated settlement. Whether it be arbitration or whether it be NCLT proceedings, really the end goal is to, bring enough pressure onto the other side. Sometimes only that, sometimes of course bring pressure, and if it doesn't work, then get your final reliefs that you've prayed for. And that's why parties go to either arbitration or the NCLT. Now, in this context, I think just a quick comparison between what the two remedies, how they work, and which one is better suited for which action. I'll just spend about 5 minutes talking about that. I've got my eye on the clock as well. Arbitrators, as Faisal mentioned, are creatures of the contract. So they are very good for contractual remedies that you want to get. And nowadays, shareholders' agreements that you see are extremely detailed. Invariably, they contain an arbitration clause. And you will see things like veto rights, where, one party, the party in management, can't usually take decisions on certain important aspects without the approval and the yes of the other shareholder. You'll see board composition, all of that. You'll see who's to manage the company. Many times investors have a right to appoint an observer on the board. They have a right to ask for information rights. So there are several of these rights, and if they're all contained in the agreement, and if the breaches and the wrongdoing of the other party can be said to be a breach of contract, then I think the contract would cover it, and one party can approach the arbitrator to go ahead validly, because all the wrongdoing is within the contours of the contract. So you don't really need to go anywhere else. A contractual remedy is typically enough. In fact, many contracts even provide default clauses where they actually say that you can end up buying out one party at a default price or at a premium price. So if, many contracts recognize even what should happen if there's a deadlock or a dispute. So if your contract is complete and you have all of these clauses, you may not need an oppression mismanagement remedy. You may be effectively be able to seek all of these reliefs in the arbitration. At the same time, the NCLT has really wide powers under the statute, and they have, they can do a lot more than an arbitrator can do as a creature of the contract. And they can take cognizance of, what equity considerations would require, and accordingly take steps. So the NCLT can actually replace the board of directors completely if they find in this oppression mismanagement proceeding that the board is absolutely not doing the right thing. They can replace it. They can even, in fact, in these remedies, say one shareholder has caused the company to enter into a contract which falls within certain contours. The NCLT can even set aside such contracts. They can set aside contracts with the managing director. So they have really wide equitable powers, which are much wider than what an arbitrator can do. So I think a key analysis that one needs to do when you're deciding, if you have a dispute that is there and you have a shareholders agreement, on which remedy is suitable, I think the end goal needs to be kept in mind. And what is it actually that is complained of? Is it something that is squarely covered by contract, for which parties have agreed matters will be resolved by arbitration? Or is it something that is possibly not in contract and merits requiring an oppression mismanagement remedy and such reliefs? So I think that is the step one. As far as step two is concerned, in comparing NCLT and arbitration proceedings, I think one is, of course, the timeline. In our courts, especially NCLT today, is so burdened with IBC matters, etc., that oppression mismanagement cases, they don't have that much time to deal with oppression mismanagement cases because there's just so much IBC work going on. And, courts in India, including the NCLTs, are pretty burdened. So after the interim relief phase, how and when are you going to get your final reliefs becomes quite critical. Because what we see in many cases, we used to, not so much anymore, but at least this is an anecdote. When I started practice, I remember in the CLB seeing and hearing of, orders directing valuation and leading to a buyout. Nowadays, we don't see that much anymore. So it's not, and of course, that's also because the growth of arbitration, and many of these disputes are now being taken to arbitration. But at the end of the day, one has to keep in mind the final relief that you want and when you're going to get it. And, when is it realistic to expect that the NCLT will have time to go really into the details of your matter, the facts, see what has happened, and then arrive at a conclusion as to what remedies, what reliefs are merited. So I think that's another critical aspect. One more, of course, is while there are these wide powers, how often are they really used? Typically, we see some kind of interim orders being granted, that too in fewer and fewer cases increasingly. But how often do the courts actually use the powers under 242 and grant these reliefs? So that's another thing that one needs to keep in mind. So even theoretically, if you have a case that can fit within oppression mismanagement, is it really realistic that you can get these reliefs before the NCLT? So those are the kind of concerns that work against the NCLT. But equally, the biggest challenge in an arbitration is the limited powers. Hi, sorry, can you guys hear me?
Yes,
The electricity just went off, so it took a minute for it to reboot.
ma'am, it's fine.
Yeah. So the arbitrator doesn't have wide powers. The arbitrator is a creature of the contract, and whether or not they'll be able to grant what you need effectively is, of course, the biggest concern. And many times we see that, of course, when you have a complete shareholders agreement, which has all the details of all kinds of rights and obligations, you may not need to rely on the jurisdiction of the NCLT. But many times we don't have such detailed shareholders agreement. Sometimes they could be very bare bones. And if that is the case, then any wrongdoing cannot be considered a breach of a contract. It does fall within the broader oppression mismanagement, and you may have to go to the NCLT. So in this context, if there are any corporate lawyers on listening, a very interesting way around this, which parties find if they want to go to arbitration, is to rely on good faith or best efforts clauses. So as I mentioned at the start, shareholders don't really have fiduciary duties. But if you put in a good faith clause or a best efforts clause, that kind of that gives you the right to say, well, whatever you did was not in best interest, and it's a really wide kind of a clause. So you could actually bring in what you would normally bring in under an oppression mismanagement relief to arbitration. Then, of course, is the time bound nature of arbitration. Try as we may, I think our courts have so much work that an arbitration which is going to result in an award at least 18 months down the line or 2 years down the line is much more meaningful to some parties in some situations than going to an NCLT. And lastly, I think the other most crucial factor in deciding which one you should go for is the interim reliefs. Because one is getting an arbitral tribunal constituted can be quite a pain, especially if the other side wants to, play tricks and not play ball and obstruct the process. Even though, of course, under new arbitration rules of SIAC, ICC, etc., you have this emergency emergency award concept. But that can be, whether or not it will be effective, nobody knows. As against that, if you go to an NCLT and there is really something serious that you want to stop and you manage to go and get an interim order, that is really meaningful. So I think the conclusion basically is, look at your contract, look at the reliefs you want, look at what you need to stop urgently, and accordingly take a decision. And each dispute is different, so it may require different approach. So I think that is really the key in deciding. Sorry, one more fact I forgot to mention is that if you have a foreign arbitration clause, because maybe one of the investors or one of the parties may be a foreign party, will interim orders of a foreign arbitral tribunal be binding? And that is something that has been a big challenge in the past. So that is also something to consider before deciding which remedy is more suitable. I have 5 minutes, so I will quickly wrap up. Actually, I think just about 2 minutes. So typically, what strategies do we see when you file an oppression mismanagement? Invariably, the party filing oppression mismanagement will add third parties, will add nominee directors, sometimes the company secretary, other officials who are said to be colluding with the shareholders. And the reason for this is very simple. Although they're not really required to be part of an oppression mismanagement dispute, the reason is that the rule that third parties can't be referred to arbitration. So what we see invariably in all of these cases is that party A files an oppression mismanagement petition. Party B will come and say, "Hey, I have an arbitration clause. It's covered by my arbitration. So please refer parties to arbitration." And then the response will be, "Hey, but there are third parties who are not parties to the contract, so we can't really go to arbitration." And particularly nominee directors, they get added all the time, and then whether they are parties and whether they can be referred to arbitration or not becomes a big debate. And one of the actually, there's a judgment of Telenor, which I forget the full name, but it's a judgment of the Delhi High Court, if I'm not mistaken, which has held that nominee directors don't come in the way of arbitration, of parties, shareholders being referred to arbitration. And similarly, there's of course another line of cases under Section 8 and 45, which says that if you claim through or under the main party, then you don't really, it's fine that you're a third party. You can still use your powers and refer parties to arbitration. Yeah, so I think I will conclude with that. Another interesting fact we see is that a lot of times shareholders bring not strictly shareholder disputes to arbitration. For example, if you have a separate supply contract with the company or some other kind of a business arrangement with the company while also being a shareholder, as a share, you can only claim oppression of your shareholder rights in arbitration. In the NCLT, you can't claim your rights under the supply or any other business contract with before the NCLT. Similarly, say a promoter shareholder is also an employee, a managing director, or CEO of the company, and he or she has a contract with the company, an employment contract. You can't claim rights under that before the NCLT, because those are not shareholder matters and therefore outside the jurisdiction of the NCLT. So these are the kind of various practical ways when the difference between arbitration and oppression mismanagement before the NCLT plays out. And I think with that I'll stop and open it up to any questions if anybody would like to ask.
Thank you so much, ma'am, and thank you, sir. It was quite an informative and insightful session. Moving to the Q&A session, we had received a lot of questions, but due to time constraint, we had to pick only few. So the ones that are lined up, I'll take them one by one. So the first question is, how effective is the resolution of instances of oppression and mismanagement through arbitration vis-a-vis proceedings before the NCLT?
Sure, I can take that. Again, that's hard to answer. Because it really depends on what the dispute is and what you're looking at. In my experience personally, I find that, again, actually, there's no hard and fast rule, because most of these days, most of them result in a commercial settlement. And the question is, what will pressurize the other party more, or what will really bring parties to the table? Sometimes it could be interim orders of the NCLT, which are really, hurting one side, and they may say, "I just want to settle it." In other cases, it may be the fact of a very expensive arbitration which you need to go through, and that there's going to be an award at the end of it. And if your conduct has not been as it ought to, then you'll be worried that you stand to win or lose. In fact, just recently, the Supreme Court enforced an LCIA award, the Ravin Cable's Vijay Karya versus Prismian, I think that was the name, which involved a shareholders dispute between parties. And I think they enforced the right to buy out or sell out the shareholding, where one party was where an arbitrator directed one party buy out the other party's shareholding. at a certain discounted value, which represented the measure of damages. So it could be any. You could have an award that gives you the remedy. You could have an interim relief, interim order that causes pressure. You could have just the fact of an expensive arbitration that you're going to go through that causes parties to settle. So it's hard to say which exactly is, like I said, every dispute is different, and one has to analyze what the dispute is to decide which is the most suitable remedy. I would only say that NCLT is burdened, and I think they may not have the time to decide very disputed oppression mismanagement cases which require multiple days of hearing, etc. Whether that's feasible or not is yet to be seen.
Thank you, ma'am. Faisal sir, would you like to add something?
I think that's a very fair exposition from a practical standpoint. I think the only thing that I would add is that, like Anuradha put it, you really have to look at the nature of the dispute. So I can give you a little bit of an instance. If the client comes to you and he is essentially or she is essentially complaining of a one-off contractual dispute, okay, some provision being violated, it's very likely, and there's no general rule to it, but it's very likely that possibly you'd be better off with an arbitration. Okay, now that's widely different from a scenario where she comes and she tells you that, look, I'm complaining of an issue which is stretched back 2 years or 3 years or a certain period of time, and I urge here an issue more of morality, of the nature of how the company is being run. It's more about the fact that I don't want to be frozen out of the business, but I'm being pushed into a corner where I will be excluded from the business. Assertions of that nature will possibly tell you that you're looking at an operation and mismanagement issue, which possibly may be better resolved before the NCLT. And if you do want to go to the NCLT, the one thing that I'd probably throw in, it's not a bad idea to put in a prayer in the alternative, saying that, failing everything else, winding up of the company, sort of a thing. And in that scenario, you might see that you might be better off in the NCLT if it's that sort of a thing. But generally, as Anuradha puts it, I would agree with the assertion that you really need to look at it. This is just an illustrative example, sort of a thing.
Okay, thank you, sir. The next question is, if the relationship between the shareholders is essentially contractual based upon articles of association, what is the hindrance in having an arbitration clause in the articles of association and resort to it rather than a petition to NCLT?
You want to take that, Anuradha?
Yeah, sure. So I think, to be honest, I have seen arbitration clauses in the articles. I'm not sure they add much to an arbitration clause in the shareholders agreement. Whether even if an arbitration clause is there in the articles, I think it would be enforceable between the shareholders. But to be honest, I've not seen anybody rely only on an arbitration clause in the articles. It's usually, I don't know if you have in your experience seen that, Faisal. I've seen only under the SHA. And as far as pros and cons, I think whatever I said would be the response, because it depends on each dispute.
I sort of second that. My experience, the limited experience that I have, I would say that I've seen arbitration clauses in SHAs, in agreements of that nature. But I mean, it just goes back. I mean, it's not so much where you find the clause or the agreement. I think it boils down to the subject matter of the issue. If it's covered by an arbitration clause, then I think it is possible to be referred to arbitration, if that answers the question. From a jurisprudential perspective, purely speaking, if that is what the question is, there is no hindrance as long as it is inter se the parties, it is of a contractual flavor, and it covers the subject matter of the dispute, third party rights not being involved or affected. I think there should be no hindrance to my mind.
Okay, thank you so much. The next question is actually on a different line, but it says, is the present arbitration law at par with other developed nations?
Do you want to take that one?
Okay, I'll start off with it. Look, at par. Now that it's There's a little bit of a controversy there. The way I understand it is there is certainly one school of law which says that in other countries where you have provisions such as 241 and 242, similar to that nature in flavor, these matters relating to the affairs of a corporation or the affairs of a company are certainly referable to arbitration. You have instances in Singapore and other such polities. So that is certainly one school of thought, that where you have a similar sort of set of provisions, matters are readily referred to arbitration. But there is this other school of thought which does say that, look, the judicial setup, the legal framework rather, is somewhat different, because in India, once the Section 8 petition is filed, there's very little that is left for the court to do, right? Then it's referred to arbitration. As opposed to that, I understand, and I'm not qualified to practice law in England, but I understand that there you can defer certain issues before the court, and after an arbitration is concluded and you feel that there are outstanding issues which are more properly adjudicated by the court rather than the arbitrator, or the arbitrator is incapable of resolving those issues, then after your arbitration has been concluded, you can revive those proceedings before the court. And those set of commentators seem to suggest that therefore your legal framework is qualitatively different, and therefore possibly not similar. I don't know if when you say at par, do you seem to suggest, possibly the question seems to suggest that it's inferior in some sense. I don't know about that, but it possibly may not necessarily be similar or akin to that extent. But if you go by those little indicators which I gave you, okay, and those are indicators of a legal practitioner, a dispute resolution lawyer, not necessarily one who only concentrates on this subject, but things that I latch on to when I try to advise the client: inter se the parties, contractual dispute, third party rights not being affected. If you follow those indicators, then if you can say safely that a matter can be referred to arbitration, to that extent, I'd say our law is somewhat similar to the other nations. But yes, it is in a stage of uncertainty. And further clarity, I think, will only come when the Supreme Court takes the trouble of pronouncing authoritatively on the subject.
Thank you, sir. Ma'am, would you like to add
No,
something?
nothing really. I haven't honestly studied this question in detail on other jurisdictions. My broad understanding is that it is similar, as Faisal mentioned. So, especially the common law jurisdictions, but I wouldn't be qualified to answer this question right now. And I think, I don't know, Faisal, if you mentioned Rakesh Malhotra is before the Supreme Court, right now?
I haven't checked the authority whether it's gone up. I understand that there is a protracted arbitration which was underway before the LCIA in Paris. Mm-hmm. But whether the question per se was taken up to the Supreme Court, I don't think so. Because the arbitration has just concluded in Paris. Another team was handling that. So I know that as a fact.
Great.
Okay, so ma'am, the next question is whether dispute as to inheritance of shares, is it like a civil dispute or regards oppression and or mismanagement? Ma'am, would you like to take this?
Oh, sure. Inheritance of shares, again, it depends on what kind of disputes. Once that person becomes a shareholder, and if you're talking about then the rights of that person in the company, it would be a shareholder disputes. But as to whether the person actually inherits the shares, I would not think that's a commercial dispute. That is, it would be in questions of succession, etc. But once that person has the shares, then of course their rights as a shareholder need to be protected.
Yeah, I would tend to agree with that assessment. The law of succession would obviously come into play here, and there you can't purely say that it is only an issue in personam. Third party rights could very well be involved. Somebody else might have a claim over those shares or whatever property you may be dealing with, and therefore inheritance and succession and issues such as those, even in Booz Allen, to my mind, I think have been found to be issues which are in rem and not purely in personam, and therefore the arbitral forum, so to speak, in that sense, may not be the best place to debate those issues.
Okay, thank you so much. Moving on to the next question, it says, as per you, what classes of disputes are absolutely non-arbitrable?
I think we'll need another session for that one.
Yeah. So I mentioned very quickly when I was talking lease, the laws relating to lease, landlord-tenant disputes. When you want to throw your tenant out of the property, if you're a landlord, there are two views there, and that issue is currently pending before the Supreme Court. So that is somewhat open-ended right now, not settled. But like we said, issues relating to succession, possibly, unless, I mean, if you have more parties fighting over it, you can purely say that it is something which is in rem, largely not capable of being settled by way of private resolution. You could have a number of other instances like that. I mean, I think the test becomes, is it one in rem? And therefore, even if you look at Booz Allen, all of those parameters and those cases are really treated to be illustrative, and succession and leases, these issues are, I think, they're indicated as being incapable of being arbitrated, illustratively. But maybe in the facts of a case, somebody says that, look, it is a lease dispute, but I'm only urging contravention of one provision, which regulates the relationship between me and my landlord, and there's no larger issue involved here. I think you could argue in that sort of a case that it can be resolved by way of arbitration, and very many of these disputes have been referred to arbitration, and arbitrations are indeed pending even in these sort of lease disputes even today. So a general sort of enumeration may possibly not be capable or wise, I think, at this stage.
Thank you, sir. Ma'am, would you like to add something?
No, nothing to add. I think I agree with that answer.
Okay, thank you. The next question is, in the case of arbitrability of claims, can the jurisdiction of NCLT be ousted? If yes, to what extent?
Is the question that can it be ousted by contract? I don't think so, because if you can't, that would be contrary to your section, whatever of the Contract Act, which says contracts in which stop legal proceedings are not enforceable, except to the extent that arbitration is agreed. But then again, you go into the same question of whether or not this is a vexatious dressed up petition, therefore arbitration okay or not. So I think, again, it boils down to the same question that we discussed earlier. So even if you put it in a contract that parties will go to arbitration and not NCLT, if there is a genuine oppression mismanagement case made out, I think that contract may not hold good.
Thank you, ma'am. So, anything that you would like to add?
I find myself in respectful agreement, I think, yeah.
Okay, thank you so much. So the next question is, would NCLT refer disputes to arbitration if the requirements of Section 8 of the Arbitration Act are fulfilled?
Yes, I should think so, but I think in Section 8, after the amendments particularly, the test is a prima facie one, even in Section 45 as in Section 8. It would refer, but I think additionally the issue which has to be looked at is the one which is enumerated in Rakesh Malhotra. I think that is more properly put the test. I think the law as it stands after the enunciation in the Bombay High Court and Rakesh Malhotra is that matters which are covered by 241 and 242 as a matter of general principle are not referable as long as you can show that they are vexatious or dressed up. That is an additional inquiry. Now, of course, you should always read Rakesh Malhotra to mean that, I think you're not talking about those pure contractual disputes. where obviously I think the simplest test inter se parties is to refer them to arbitration.
Thank you, sir. Ma'am, would you like to add something here?
No, I agree.
Okay, thank you, ma'am. Moving on to the next question. Are the provisions of the Arbitration Act 1996 repugnant to the provisions under Section 9 of the Companies Act?
No, I don't think so. I think that it would come to be a little bit of a shock to people today if you were to argue that. The Arbitration Act has come here to stay, and in that sense, a constitutional challenge of this nature may not have been mounted, but the vires of the Arbitration and Conciliation Act have certainly been tested. Maybe not particularly in the context of the Companies Act, I'd have to check, but merely by the fact that the parties can agree to have a private resolution of their disputes, particularly in issues which concern them inter se, their relationships. The Arbitration Act makes a provision to have those disputes resolved by way of a private sort of a resolution mechanism. That is certainly not repugnant in the context or in the sense of Section 9, as you would find it, that it is contrary to a statutory provision in the Companies Act, because I think the Companies Act does not expressly bar you from having a private resolution in that sense, in a matter which pertains only to the parties or to two groups of shareholders. So I think that you can safely assume that it is not so repugnant. I don't think that question needs to be entertained very much today.
Okay, sir. Ma'am, would you like to comment on this, or should we move on to the next?
Yeah, just one thing. I've forgotten the details now, but I think under before the 2013 Act, under the 1956 Act, I think this question may have been examined. It was, and I think the conclusion was that both were separate codes. The Companies Act was a code, and the Arbitration Act was a code. And to the extent that they were not contrary, there was no repugnancy between them. And in fact, this was in the context of where appeals would lie. And we had that controversy even now. Yes, in fact, that's an interesting question, because in the context of appeals, because the Arbitration Act under Section 37 does not allow appeals from when an NCLT allows a Section 8 and refers party to arbitration, you can't appeal that. But if an NCLT rejects a Section 8 and says, sorry, no arbitration, that is an appealable order under the Arbitration Act. Now, the question is, would this override the new NCLT provisions which provide for, or the Companies Act provision which provide for appeals to the NCLAT? And the NCLAT has actually held that appeals are not maintainable from NCLT orders which allow arbitration. So actually, in that sense, they've held that the Act overrides the Companies Act to that extent. If that's helpful, I don't know if that answers the question, but there's no repugnancy as such. They operate in their independent fields, and the courts have actually harmoniously interpreted the two when it is relevant.
Thank you, ma'am. I think you both have answered that question. Moving on to the second last question, it says, who has the right to file a petition concerning oppression claims? Faisal, sir, would you like to take this?
Yeah, I mean, so before the NCLT, to my mind, subject to Anuradha having a broader view of it, or a more constructed one, it can certainly be a member, can be a shareholder, but it could be somebody else, as long as you're able to show that there is some sort of an operation in mismanagement which affects a larger public interest also. I think in that sense, the provisions are more broad in that sense. If you can bring in public, the interest of the public, it could be a third party also, to my mind. Of course, you would have to plead facts to show how you are affected and in what sense the public interest is affected.
I have nothing to add.
Okay. Moving on to the last question, can the arbitration agreement be made part of the Articles of Association instead of a separate agreement?
I think this is similar to the question, and I think as Faisal mentioned, if it's there and it has the flavor of a contract, it can certainly be made part of the article.
But we might add that neither of us have seen it in that form. Okay, so that's something you might want to keep in mind. But jurisprudentially, is it incapable of being there? I don't know. I don't think so. It could be, but not to our eyes have we come across it in that form yet. Yes.
Okay, thank you so much, sir and ma'am. Looks like we have covered all the questions. Is there anything else that you would like to add?
Nothing apart from the fact that I'm very happy to be here. I just wanted to reiterate that delightful sharing the screen space with Anuradha. That's about it. And thank you very much again for making this possible today.
Yeah, thanks from me too. It was quite interesting and definitely very nice to meet and speak with Faisal. And I hope it was helpful to all the participants. And thanks, of course, to all for organizing this and letting us be here.
It was quite an insightful session, and thank you on behalf of LegitQuest and Mr. Karvan Kalia to spare your valuable time for this Legit class. It was truly an honor to have you both. Before I leave, I'll just apprise my participants that this class was organized by LegitQuest, which is an artificial intelligence-based legal research product. It is a state-of-the-art legal research platform for conducting legal research and is very well known for the introduction of the world's only one-click insight system called the iDraft. In short, iDraft feature powered by artificial intelligence takes out the issue, facts, arguments, reasoning, and decision of a case law. LegitQuest has recently started with LegitI, which has latest news, interviews, and columns and serves the stakeholders of judiciary. So I would like to thank all the participants, and for recording of this Legit class, you can subscribe to LegitQuest YouTube channel. Thank you so much, sir and ma'am. Thank you once again.
Thank you, Chad.
Thank you. Good evening.
Bye-bye.